on the grounds it was denied. So June 2009, a jury entered damages for Marla for 1.9 million for past and future economic damages, and then another 4.4 million for damages for loss of companionship and pain and suffering. So counsel for Bahama Diver filed a post-judgment motion for reduction of the verdict based on Bahamian law. Ms. Marla filed a notice of hearing, and on June 2009, counsel for Bahama Diver served a notice of withdrawal of defendant's post-judgment motion for the reduction of the verdict based on the application of Bahamian law. And then 3 months later, final judgment was pronounced by the judge in Florida, and they awarded her $6.3 million. What you see was wrong with Bahama Divers as a company? What did they do wrong? In all those steps.
I know you said they didn't file a defense.
No. Then they started on this road by arguing that the matter should be heard.
Bahamian, right? Bahamas, yes.
Yes. And so then started here. And then remember, that motion was denied, but they didn't appeal it.
Oh, appeal. Okay.
No, they did not appeal it.
Oh.
They didn't go to the court to find out why. Then
sorry. So you're saying if they had appealed it, possibly they could have had the case tried here?
Yeah, because then the argument would have been upon jurisdiction. So what you do is you argue before the court that the place, Florida court is not the right place. See, it would be Florida court because he was a Floridian, an American. Okay, that's Ms. Craman's side. But on his side, he could have argued with the court that, guess what? It's a Bahamian company, Bahama Divers, 1. Number 2, it happened in the Bahamas. And 3, everything related to this incident is in the Bahamas. And so the judge would then consider on the basis of probability whether or not the locus should actually be in the Bahamas. But he didn't appeal. So he doesn't know, they don't know the reason why the matter was not heard. So they awarded the damages.
Just a question too, Ms. Archer. Did Bahama Divers pay? That seemed like a lot of money.
Oh, we could get.
Oh, okay.
You really believe Bahama Divers have that kind of money?
That's what I tell you, when I heard the amounts, it became a little interesting to me. I go, okay.
No, they couldn't pay.
Okay.
No, they couldn't pay. They went out of business.
Oh, okay.
Right. So then they applied to have the $6 million reduced. And then they withdrew it. So in my mind, I'm wondering if Bahama Divers thought that it would just disappear. So, as the United States is not a prescribed country for the registration of foreign judgments in the Supreme Court under the Act, Ms. Marla commenced action in the Supreme Court, of course, to enforce the judgment. So, at first blush, one would expect this to be a relatively simple matter, but 8 years later, it still languishes in this court for reasons which will become obvious momentarily. A review of the court's records demonstrate that the action was met with many challenges. For convenience, I shall only refer to the more important applications. So we gone from 2009, where Bahama Divers withdrew the motion to reduce the verdict, to now 2012. So in 2012, Bahama Divers filed a summons to strike out Mala's writ of summons. Then in August 2013, Bahama Divers issued a third-party notice to Summit Insurance, as their insurance, alleging that in the event Mala is found liable, in the event that Bahama Divers is found liable to Mala, then Bahama Diver claims that it is entitled to an indemnity or to a contribution from the insurance company. So in June 2014, the third party filed a summons to strike out all subsequent third party proceedings under the rules in the Supreme Court. Then in February 2015, Evans J. ordered that one, the summons for summary judgment filed on behalf of Mala and the summons filed on behalf of Bahama Divers would be heard on April 2015. And then they gave directions to prepare for the hearing. So in April 2015, the defendant's basic challenge as Bahama Divers, according to the learned judge, was to the capacity of Mala to bring the action, and they say that the action itself is a nullity due to Mala's lack of capacity. You understand what that means, right?
No.
Okay, so lack of capacity means that they're saying that Mala doesn't have any, more or less no right to bring this matter before the Bahamian court. So in a written ruling delivered on May 2015, the learned judge dismissed the summons brought by Bahama Diver. It appears that an appeal was filed and that too was withdrawn and dismissed. So subsequently, the matter came before this judge, Nandira Charles, when she gave direction and she fixed a hearing date. So this matter's been flopping from side to side to side to side for years. So in order to have a better understanding of the case, I settled fully the statement of claim and the defense. This is because, in my view, learned counsel for Bahama Divers, Mr. Roll, raised further defenses which were not pleaded. It also appears that facts which ought to have been properly admitted were not, and Mala was put to strict proof of her assertions. So in the statement of claim, it is alleged that on or about the 6th of May, 2004, Mala commenced an action claiming negligence resulting in the wrongful death of her deceased husband against Bahama Divers Company. The company was incorporated under the laws of the Commonwealth of the Bahamas and Reservation Services International, Inc., incorporated in the state of Florida, and they were cited as the defendants in the case in Florida. Instead of simply adding straightforward facts, Bahama Divers makes no admission and puts Mala to proof thereof. So at paragraph 2, the statement of claim, Mala pleaded that the case against Reservations International, Services International, was subsequently dismissed and the action proceeded against Bahama Divers. So once again, instead of admitting these simple facts, Bahama Diver makes no admission and put Mala to proof. So what it's saying is that Bahama Divers is not arguing against these facts. They're saying she has to prove that Bahama Divers was at fault. So Mala, in her statement of claim, she said that pursuant to a motion for default filed in Florida, a default was entered against Bahama Divers on 22nd of December 2004 for failure to serve or file any paper as required by law. The effect of which under Florida law was an admission by the defendant as to liability in respect of the claim by Mala for damages resulting from the death of the deceased. So because he didn't file any paper, the court gave that as an admission of guilt. So this assertion is supported by documentary evidence, which Bahama Divers ought to have had in its possession and ought to properly admit. Bahama Divers also denies that it admitted to liability with respect to Marla's claim for damages resulting from the death of her husband. So Marla stated that notwithstanding Bahama Divers' default and pursuing to the Florida law, a jury on the 4th and 5th of June had a trial to determine the quantum of her damages. Bahama Diver makes no admissions and puts again Marla to strict proof and facts which were evidently clear from their own post-judgment motion filed in 2009. Bahama Diver then raises the defense that it had no obligation to appear before court in the state of Florida and denied that it ever submitted to the jurisdiction of the Florida court. Although it is plain from the final judgment as exhibited that they filed a notice of appearance on behalf of Bahama Divers. So in the legal proceedings commenced by Marla against Bahama Divers in Florida, in spite of documentary evidence to substantiate this assertion, Bahama Divers still did not admit this fact and puts, of course, Marla to proof. Marla states that the circuit court was duly constituted and held in accordance with the laws of the state of Florida and has jurisdiction to determine this matter. Bahama Diver makes no admission to Marla's assertion and denies that the Florida court had jurisdiction to determine the matter. Now remember now that their application was denied and they didn't bother to appeal it. So again, she's talking about her award in Florida of $6 million. So at paragraph 32, Bahama Divers then turns around and pleads that the deceased wholly caused or contributed to his demise by his own negligence. This Bahama Divers is now saying that the deceased husband contributed to his own death. They said, 1, the deceased failed to take care of his own safety in a sufficient and proper manner and was reckless in this regard. The deceased failed to use any or all reasonable care and conduct so as to ensure his safety. The deceased refused the assistance of a dive guide, which the defendant could have provided, and instead chose to dive with a group of persons who were certified divers, as was the deceased. The deceased left the group with which he was diving by himself in contravention of diving protocol and attempted to reach the surface alone and without assistance of the persons in his group. And the deceased failed to alert any person in his dive group that he was about to swim to the surface, or in the alternative, that he was in any danger, immediate or otherwise, as is the protocol in such circumstances. So, as properly identified by Marla, the defense raises 3 discrete defenses, namely, whether Bahama Divers submitted to the jurisdiction of the Florida court, whether the Florida court had jurisdiction to hear this matter, and 3 was whether there had not been a proper trial on the merits in the Florida court. So the judge says, in my opinion, the findings of the circuit court, which are settled below, are a complete answer to all the defenses advanced by the defendants. So the court finds that the defendant, Bahama Divers, was properly served the complaint in this action pursuant to the Hague Convention on the service abroad of judicial and extrajudicial documents in civil or commercial matters. The court finds that the defendant, Bahama Divers, failed to plead or otherwise defend itself as to liability in this action, notwithstanding being provided copies of all papers and proceedings in this action. The court also finds that Bahama Divers did not exercise his right to request that this action be transferred to the Bahamas. And the court finds that Bahama Divers voluntarily appeared and defended itself as to the amount of damages due to Marla and was provided a trial by jury with the right to present evidence, witnesses, and arguments of counsel. Wherefore, the court enters its final judgment as set forth herein. So you see why at the very end, the judge said in her final judgment that Marla won the matter for the $6 million because they didn't defend themselves at all. So Bahama Divers was a 55-year-old operation, and it has been forced to permanently close its doors with a loss of 15 full-time jobs after a $9 million judgment was forced against it over a customer's drowning. Matthew Whiteland, owner of Bahama Divers, which was founded by his father in 1965, told the Tribune Business that court bailiffs arrived to seize the company's assets within 48 hours of its reopening following the first COVID-19 lockdown. Branding the company's fate as a big mess, he argued that it would be impossible to even come remotely close to recovering the full $9 million award from Bahama Divers liquidation, as the company's gross annual sales barely turned $2 million per year. So notwithstanding that liquidation receivership costs might exceed the company's net worth, Mr. Whiteland said he was leaving the deceased U.S. divers family and their Bahamian attorneys to figure out who gets what with the court, plus Bahama Divers bank and landlord, both of whom are claiming that monies are owed to them. He said it was a sad day to close his business. He said he hoped to re-enter the dive business via a new venture. And he pledged that ex-Bahama Divers staff would have first spot, but suggested this may take some time due to the likely difficulty in attracting investment and financing for tourism-related business. He says that everyone kept telling me that cannot happen. He said it's very unfortunate and very sad, and I guess his wife, that's Marla, I know they tried to sue a bunch of people in the United States. That didn't go anywhere. And they found a loophole to sue us in the Florida courts. They got a judgment for $9 million, came to the Supreme Court, and the Supreme Court enforced it. That's what it was over. He said when they liquidated everything, it's nowhere near $9 million. We couldn't pay the rent, and we have no inventories, no boats. So the bank is mixed up in this. They have a debenture on the overdraft. The landlord of the rental unit we were in is saying he's keeping it. That's the company's property because of unpaid rent. We were closed since March because of COVID and not able to pay rent at Nassau Yacht Haven. It's a big mess, and I don't know how they're going to figure it all out. Who's going to get paid and who isn't? They might have seized everything, but it's far from over from whoever has to liquidate everything and recover the money. Any comments?
That's a very sad case.
Yeah.
But another question, I guess, Ms. Archer, does it all like the lawyers, I guess whoever Bahama Divers lawyers were, would it kind of speak to, I guess, their lack of argument, or like, I guess what I'm trying to say is if you have a better chance, depending on who your lawyer is, who you choose as your legal counsel in terms of any case. Okay.
Mm-hmm. Yeah, because he put in the application and then he withdrew them. Yeah. He should have represented Bahama Divers and pleaded their case. And guess what? On an appeal, the judge may have said, guess what? All of this happened in the Bahamas. And then Bahama Divers, if he was a frequent diver, may be able to say that this man has been our customer for 5 years or 10 years, and he's always diving here and this. And the judge may have said, let this matter be heard in the Bahamas. But you know, she got
but also,
go ahead.
Sorry, I thought you had stopped. I mean, no. Only thing I was going to say is, I thought, I mean, I may be wrong, that a company's articles usually state the jurisdiction in which the court would rule. So, I mean, I'm thinking that that is what the lawyer must have originally advised them, that the Florida court had no jurisdiction, based upon the fact that it was a Bahamian company and, you know, the legal jurisdiction is here as well. I'm thinking that's why they didn't respond. And also, I didn't know that under Bahamian law, you could sue for emotional damages, or at least not to that extent.
No,
I'm just surprised it was upheld.
she would not have gotten this kind of figure. That's probably why she pushed for it over there. She
Yeah,
would
I'm
not-
confused. I feel like they weren't protected at all. I mean, I've never heard of anything like this ever. I mean, I remember when, like I said, when it came up in the papers.
But that's what, after it came up in the papers, is what drew me to this last year. I said, this case has to be published by now. Let me see what happened and why it happened. But you can see it all fell down from when the matter went to the United States. He should have fought from then to have it brought here. But he withdrew the application. He withdrew it because guess what? Even the contracts that he signed to go on this diving expedition with everybody else should have had a provision that is governed under the laws of the Bahamas.
Absolutely. And it probably
Okay.
did, to
But
be
yeah, but
honest.
Yeah, but he didn't go to the court to argue it in Florida.
Yeah, somebody dropped the ball, and I have a funny feeling it's his legal counsel.
Who at that point in time? Because it may not be the same person. Because it doesn't speak to who his counsel was at that time. We only know who his counsel is at this point in time. But the damage had already been done.
It's crazy when somebody, something like that can wipe out an existence of a company that's been in place how many years? Actually, I remember when they first opened up. My brother
Yeah.
even worked for them years ago.
Mhm.
And I kind of knew the original Bill Whiteland, the father. I mean, he would never know me walking along the street, and I'd never let him know I knew him. But the fact is it's crazy. You know, all laws are supposed to protect us and our
Mhm.
companies and our businesses, and then the Florida law just comes in and wipes it all out.
So he see here in this article, his interview with the Tribune, he says, let me see, right here, because I didn't highlight the different parts. Let me see where he says, he said, disclosing that efforts to enforce the judgment against the company first began in the Supreme Court in 2008. He added that he was repeatedly told over the course of a 12-year legal battle that an award to the extent of $9 million can't happen. That's what he was told. But that award
Right. He felt he was protected. Yeah.
wasn't.
And everybody knows that Americans come here and they have, I mean, not to discriminate, but they come here so they don't have to follow laws. They think that, you know, they can do whatever they want. And for some reason, I can't help but think this was a classic case, because I know that there are a lot of strict guidelines for these divers because of this situation right here.
Yeah. But I found, as I said, this is a very, very good case. And nothing related to, like you said, the contract or the articles, none of that. All of that could have been done when he would have stood his ground to say why this matter needs to be transferred and heard in the courts of the Bahamas. One, that the principals are Bahamian. The company is a Bahamian company. The article said that everything done by this company is in accordance with the laws of the Bahamas. The contract that he signed should have said, governed by the laws of the Bahamas. It should be heard in the Bahamas. There's no way she would have gotten $9 million. Now, I don't know what he did. See, and that's another thing. Because if he'd gone to court, you'd have been able to hear her plead why in her view, she should have gotten so much money. So for future economic damages, I don't know how old he was, they gave her 1.9 million. But For her loss of companionship and pain and suffering, they gave her 4.4 million.
Yeah, that's crazy. I mean, you can't replace somebody's death with money, man.
No. So I mean, so she walked off, and after he had to pay legal costs, that's a $9 million bill. He cannot pay that in his lifetime or his children's lifetime. Yeah. But he should have argued and steered this in the right direction, because this was not in his personal capacity. This was Bahama Divers, the company. Yes, I know. Don't be so sad. But it's a good case. All right. So let's talk about directors now. So we know directors have a fiduciary duty. And that duty is a duty to manage the company and always act honestly, in good faith, and in the best interest of the company. Subject to the unanimous shareholders agreement that we discussed in the last class, and also the articles of association. They have to exercise their duty of care with diligence and skill that a reasonably prudent man would exercise in such a position. So whether they're an executive or non-executive, they have that same duty of care. So a director is a fiduciary. And that means that they must always act in good faith, not make a profit from their position as a director. They can't put themselves in a position where their duties would conflict with their own personal interests. They have to act for their own benefit and the benefit of others. And when necessary, they have to get consent where it's applicable. But they always have to make sure that they're following the memo and articles, and they deal and treat fairly all the classes of shareholders. So we know that on incorporation, the first directors are appointed, and then subsequent directors are appointed according to the articles and the shareholders agreement. So the articles normally tell you when and how a board will fill a vacancy. They also tell you about appointment of additional directors and the maximum amount, or how a director can be removed. So on appointment, a new director should signify his or her consent to act as a director, execute a director's service agreement, obtain the relevant insurances and indemnities, and get a copy of the corporate documents. So if you're talking about like a private company, or a large private company, or a public company, the company's secretary would provide you with a package. And that package nowadays is on the electronic directors, what they call it, pad. And that would have the memo, the memorandum and articles of association, copy of all policies and procedures, the minutes, organizational structure, confirmation of dividend payment, all the things that a director would need in order to sit at the next board meeting and be aware of what's happening. So there are normally two types of directors, executive and a non-executive. The executive director is one that works full-time with the company, and the non-executive director is one who just attends the meeting and he gives advice to the board based upon his expertise. But in company law, there's no distinction between executive and non-executive directors. Now, you could also have a nominee director, and that could be a corporate director, or it could be a person, and they will act as directors on behalf of another person. And then normally they would sign a nominee directors agreement or corporate management agreement. Then you'll have in some organization, depends on the activities. Mostly you'll see this in manufacturing companies or like companies that rely on different persons to make contributions to the board and help in decision making. You would see something called a shadow director. Now, shadow directors are recognized in our company's Winding Up Act, and it's defined as any person in association with whose directions or instructions the directors of the company are accustomed to act, but the person is not deemed to be a shadow director by reason only that the directors act on advice given by him in a professional capacity. So like I said, there's someone who comes into the meeting and the directors may ask them to come in to give an advice on a professional matter. Now, if that person comes to the board meeting frequently, and that person, based on the minutes, sways the directors in terms of how things should be done and how it should be voted upon, then the courts may deem that person to be a shadow director. So if a person or entity is considered to be a shadow director, they are held liable for all legal obligations and liabilities of a director, duly appointed or acting in the traditional sense. And whether someone is a shadow director is a subjective one. And what the courts look at is whether or not they have real influence in the corporate affairs of the company. And whether that real influence was wielded over the corporate governance of the company. And they look to see whether or not he acted on equal footing with someone who is an actually appointed director. So the recognition and judicial treatment of shadow directors is to protect the stakeholders of a company from management of persons who are unelected or non-appointed persons. So as I said earlier, a director is a fiduciary. And a fiduciary means that he must always act in good faith. So they act as fiduciaries for the shareholders of a company and custodians of its assets. So they have legal and statutory duties. The duty to act in good faith and promote the success of the company. The duty to act in accordance with the company's constitution, to act in the best interest of the company, to exercise reasonable skill and care and diligence, to exercise independent judgment, to avoid conflict of interest, manage the company, and treat different classes of shareholders fairly. And this case that we're about to do, Zone America, is a good one. So who do they owe these general duties, or who are the beneficiaries? In common law, the duties of directors is owed to the company. Only those who are able to act as or on behalf of the company can enforce those duties. And by whom are the general duties owed? Those who have been properly appointed as directors of the company. So even though you have shadow directors, in the case of Reed Smith and Fawcett, directors must act in the best interest of the company and cannot use their powers to benefit themselves or third parties. Any questions so far?
I thought there was some sort of restriction on nominee directors. I mean, I know the recent like FATF guidelines has introduced, I know, new framework or whatever with respect to appointing them, but don't we have, isn't there some restriction on that? Like that, like you can't have them anymore?
I know some FCSPs are trying to move away from being that. A lot of them are turning them over now and asking the companies to appoint their own directors. But I don't remember any communication coming out saying you cannot have nominee directors. Because I think a lot of the FCSPs are looking at the liability. Because remember now, we incorporate those companies and we would maintain those in terms of making sure they comply with the laws, but they don't really know what the company is doing. Transaction-wise, they have no clue. So that's
Yeah, I don't know, maybe it's because of the risk involved that, you know,
Yes.
I mean, I know we absolutely, and also I thought there was a look through as to liability as well. Like, so in other words, a nominee director it's not even a thing, because once you are listed as a director, the liability can potentially fall on you.
That's what I'm saying now. And that's why I'm saying some of the FCSPs are now trying to replace themselves where they have nominee directors, to advising the companies that you need to appoint someone. They're shifting to that because of that liability. But like I was saying, I don't recall seeing any communication from either SCB or the Compliance Commission in that regard.
Yeah, I'll look into it again. I mean, I just know it's a big no-no where I work. I should have listened better as to why, but I thought it was, I don't know if it's amendment from the, in the recently, you know, restated or whatever it's called, the FCSPA. I'm not sure, but anyway, I'll take a look.
I'll look too, but I know they are moving away from it because of the liability. I know that. So a director has to always act in good faith. And that good faith means that he must always act in what's in the best interest of the company. Directors also must exercise their powers for the purpose for which those powers were given. So they can't just simply act in good faith in what they believe to be in the best interest of the company. Anyone read this case? Zone America?
I attempted it.
Oh, okay. Well, attempt is good. Anybody else attempt it? Don't sound so. It is the duty of directors to exercise their powers for proper purpose, that courts fairly and objectively monitor and assess the propriety of the decisions and actions of company directors. That means it must always act in the best interest of the company. And that is a subjective test, and arguably more suitably determined by the judgment of directors who operate and manage their companies within the parameters of proper and appropriate ethical behavior. Directors must be seen to be exercising their discretionary powers independently and fairly in all matters, particularly those involving their shareholders and in contractual relationships with external and internal parties. Remember that for when we start to go through the case. Directors must be seen to be exercising their discretionary powers independently and fairly in all matters, particularly those involving their shareholders and in contractual relationships with external and internal parties. In the case of Movitex versus Bullfield, it established that directors do not have a duty not to place themselves in a position of conflict or in and of itself. They should not place themselves in a position where their personal interests or duties to third parties conflict with their duties to the company for which they are acting as directors without the clear, unequivocal consent of the company. Directors may be given such consent in the provisions of the Articles of Association of the company or by an ordinary resolution of the company. Directors are also prohibited from gaining a profit or obtaining some benefit by using proprietary information or trade secrets or opportunities that may belong to or derive from the company for which they act as directors. Under the Companies Act, Section 84 and Section 40 of the IBC, the duty of directors to manage the business and affairs of the company, subject always to the memorandum and articles and any restriction thereof, and the shareholders agreement. The primary fiduciary duty of directors is to treat all shareholders fairly, particularly where to do so would be in the best interest of the company. So directors do not have unlimited powers to run a company on behalf of shareholders. They can only exercise the powers that is granted to them by general law and what's in the articles and what's in the shareholders agreement. The ambit of a director's authority is restricted by the Companies Act or the IBC Act and the articles. The articles usually entitle the board of directors to delegate powers to individual directors as considered appropriate, and directors must act collectively as a board to bind the company. So a director cannot be liable for fraud or fraudulent, criminal, or bad faith acts of his co-directors. But if he is involved in that act, he is jointly and severally liable with his co-workers. And he may be required by law to make good the whole loss with a contribution from his co-directors. So directors may be liable to account for any secret profits he may have made, and in such a case, the company will be entitled to void any contract it may have made with him. Any company property that a director may have taken or transferred to a third party may be recovered by the company, except those that would have been purchased by what we call a purchaser for good value, which means that the purchaser didn't have notice that the company had an interest in the property that they purchased or the asset that they purchased. So a company may, by ordinary resolution, waive a breach of duty by a director, and they can do that. The court has power to grant relief to a director who acted honestly and reasonably in view of the facts and in the circumstances, and then the court may exonerate them. So a director under the Companies Act, it allows for a director and his legal representative to be indemnified by the company for all costs, charges, and expenses that may be reasonably incurred for any civil or criminal or administrative action. And under Section 58 of the IBC Act, the director has the same protection, subject to the memo and arts or a shareholder agreement. The statutory right to indemnification is only permissible to directors and their legal representatives of both the CAC and the IBC, provided that such directors acted honestly and in good faith in the best interest of the company, or where they had reasonable grounds for believing that their conduct was lawful in the case of a criminal or administrative action, or proceeding involving a Companies Act company that is enforced by a monetary penalty. Now, in most companies, once a person is appointed as a director, and in some instances, the officer, they always ask the accountant or the company secretary to read the insurance policy. So directors and officers may be personally liable to any party that may have an interest in the affairs of the company for damages, legal costs, and expenses in relation to the breach of a director's duty. And many of them seek the protection of the directors and officers' liability insurance. So directors and officers' insurance are designed to protect the director or officer against claims that may be made by a company, a shareholder, or creditor. Under CAC Section 122, a company may purchase and maintain insurance for the benefit of a director against liability. And under Section 58 of the IBC Act, it also allows a company to purchase and maintain insurance for a director a registered agent, an officer, a liquidator, against liability. In such case, acting in their capacity as a director, a registered agent, an officer, or a liquidator. Now for officers themselves, the general statutory duties do not apply to managers who are not directors of the company. So notwithstanding that, when you're applying the law relating to directors' duties, the courts do not distinguish between the actions of the director as director and actions as a manager, where the director is an executive. Those duties will apply to both aspects of the director's activities. Therefore, some actions by senior managers of the company, provided they are also directors, will be subject to the controls of general statutes. So in addition to company directors, officers carry out the operational and daily mandate and activities of the company, and they oversee the supervision of critical corporate duties and responsibility. So officers are normally answerable to the board of a company. And then after that, I just give you the sections that speak about the directors in the CAC and in the IBC Act. Any comments?
I would just like to go back actually to directors indemnification versus, and the liability insurance part. I mean,
Okay.
in one instance, it says the directors are indemnified. So let's go back to that wonderful question about Betty and Ty Limited. Would she, I mean, you know, I'm only using that because it seems to be completely connected to this section here.
Mhm.
I mean, what I understood from that question was that, I mean, it didn't seem like she was aware necessarily. I mean, there was no personal gain to her that I could glean for her entering into a contract that exceeded her authority. So would she, is it the thought that she would be indemnified because she acted, she believed that her conduct was lawful and
Yeah.
it didn't exceed her administrative powers?
You think what the crux of it is, I'm a director, right? She must always act in the best interest of the company. So first of all, was that decision that she made in the best interest of the company? That's the first thing. You see, the part about liability only comes about when the board themselves are going to say this is not in the best interest of the company because we're now going to be exposed to a liability. So remember what I said, when you answer those questions, you have to give the assumption, because the question doesn't give you full details, you have to make the assumption by saying, first, that she was not aware of the limit. That's something that can be challenged, because in that role, there's certain things you need to know before you even act. What authority do I have?
I understand. So I think I understand. So the liability, if she had had liability insurance, would that, if she was found, you know, personally liable for that error, would her liability insurance cover her for that act, or does that insurance only cover for external acts?
No, the insurance covers both internal and external if it is within the powers of the company. If the company decided that what she did was outside of her authority and she should have known better, she will not be covered.
Can the company decide that though? I mean, wouldn't that have to go to court to be decided?
Yeah, to court. Yes, to court. They would have taken it to court. And that's why I'm saying,
Okay, thanks.
when you become a director, there's certain things you need to see. One, what's your limits? What are you authorized to do and cannot do? And then you need to read the insurance. Because I can tell you a lot of persons, once they are appointed directors, I know the foreigners normally do it. That's the first thing they do. They come to the company secretary and they say, I want to see the insurance policy that relates to my role. That's the first document they ask for. They want to know what they're covered for. And trust me, sometimes when you send them around documents to read and give their vote on, they're going to tell you, hold on a minute. What's my exposure in this transaction? And will I be covered under the insurance? Because there are a lot of caveats under these bankers blanket insurance and professional indemnity insurance. Now, they're very careful what they sign on to. So that protection is not a wide protection. There are limitations, restrictions and concessions and all kinds of things. So where it says here that a company may purchase and maintain insurance for the benefit of a director against liability incurred by him in his capacity as a director of the company, but it has to be something that's being done in the best interest of the company itself. And was she acting within the limit, her authority? And even looking at the amount. Let's just say she was new. She should have contacted the chairman of the board. Am I authorized to sign off on something in this amount? Or she could have gotten the minute book and look at other transactions. Or she could have spoken to the CFO.
Or as in many cases, she'd probably been there a really long time and transacted many of these things in the past and just
Right.
felt she had carte blanche to do it.
Yes. Yes. That's another one too. But company law is exciting. You don't think so?
Not really.
All right. So you all asked for it. So I decided to find this lovely case that was done right here in our Supreme Court called Zone America Limited and Ferdinand Hutz, AKA Ferdinand Hutz and Carl Hutz. And this was done by our now Chief Justice, Ian Winder. And it's a recent case. All right, so let's go to paragraph 1. So this is a claim by Zone America Limited against the Hutz, alleging breach of their fiduciary duty as directors of Zone America and for unlawful interference with Zone America's economic interests, which Zone America says it caused it to suffer a loss. Everybody understand that?
Yes.
Okay.
Yes, ma'am.
Okay, all right. So this is exactly what we were just talking about, right? Directors with their fiduciary duty. And they said that they interfered with the plaintiff's economic interest. So that means that they were not acting in the best interest of the company. And therefore, the company suffered a loss. So Zone America is an IBC. It is owned by Zone America SA, and it has 2 subsidiaries in Uruguay. The shareholders of Zone America is a company called America Real Estate Investment that owns 56.5%, and another company called Sienna Enterprises that owns 43.5%. Now, Ferdinand Hutz is the ultimate beneficial owner of Sienna. Ferdinand Hutz were also directors of Zone America. So you have the picture? I normally like to draw the picture. So you have the very top, you have America Real Estate and Sienna Enterprises. On the top of Sienna Enterprises, you have Ferdinand Hutz. And Sienna Enterprises, ultimate BO, are the directors of Zone America. And Zone America has 2 subsidiaries. Now it tells you here that the directors period was from July 1998 to March 2006, 2010 until 2013. So in 2012, so they were still directors, representatives of Zone America and the subsidiaries in Uruguay, they were in discussions with Deutsche Investiones with regard to a subordinated loan in the amount of $20 million. So DEG, that's Deutsche, issued a letter of intent setting out the terms and condition of the loan. Now, Ferdinand Hutz were not personally involved in the negotiation relating to Deutsche Bank subordinated loan. In May 2012, Federico Perez, he was the finance manager of Zone America. He sent an email to the Hutz attaching a copy of the letter of intent. And in that email, he stated inter alia that we are in the process of negotiation, and we hope that after the due diligence that will be done soon, we will see if we can improve some conditions. For example, to obtain some reduction in the rate. So on the 21st of May, that's 3 days later, the Hutz in their capacity as representatives of Sienna Enterprises, shareholder of 43.5% of Zone America, and as directors of Zone America, they sent a letter to Deutsche. And they said, I refer to your letter of intent concerning the $20 million financing. We are writing to you as representatives of Sienna Enterprises, shareholder of 43.5% of Zone America, and as directors of Zone America. And then they go down and they say, for good order, we notify you that we will use all means available to us to block this loan or the repayment thereof. So on May 2012, representative from Deutsche sent an email to the Hutz stating that we are not aware of the fact that our discussion with Zone America Limited for a long-term loan were not known to you as shareholder and director. Naturally, we would only proceed with the evaluation of a possible financing if there is a consensus among all shareholders and directors. So on the same date, Zone America wrote a letter to Deutsche enclosing a copy of Zone America's amended and restated Articles of Association. Anything wrong there? What do you see happening?
They are just trying to like rectify, I think, any issue that may have happened before. So they're like working around, they've seen something and now trying to, I guess, correct it. They're going against what I guess the original information was.
Well, see, now don't forget, now they're getting a very large loan of $20 million. So they're doing this restatement, I think, in order to have the capacity to borrow this amount. whatever the conditions are with the loan, they have to make sure that the articles allow them to do it. But at the same time, their director, who is also their shareholder, is saying he's not aware of this. And he's not in agreement with it. See, because he says in paragraph 10, let me read it. He says, on Friday, the 18th of May, 2012, Federico Perez, CFO of the Zone America Group, phoned us and sent us a mail containing the aforementioned letter. To our great surprise, he told us that Zone America had signed a letter of intent with Deutsche regarding long-term financing of the group, and that representatives of Deutsche would be coming over for due diligence in a matter of days. We have not been consulted in this matter, neither as shareholders nor as directors. Neither are we aware of a board decision concerning long-term financing or of a decision giving mandate to the management to start looking for such a financing. In our opinion, there is a serious breach of the corporate governance of the company. Furthermore, we cannot agree with the terms and conditions you are offering for the financing. For good order, we notify you that we will use all means available to us to block this loan or the repayment thereof. That's what the HUT said to Deutsche Bank. So in April 2013, so in May 2012 and the 30th of May 2012, after Zone America sent Deutsche their amended and restated articles of association, there was an exchange of emails between Zone America and representatives of the HUTs, whereby Mr. Miller provided the HUT's representative with further information regarding the Deutsche subordinated loan. So in April 2013, almost 10 months later, Zone America and the subsidiaries negotiated a loan from Banco Itaú and Banco Balboa Vizcaya for an aggregate amount of up to $20 million with a 2-year grace period and a 5-year repayment schedule and an interest rate of 7%. And that wasn't bad. The defendants were not involved in the negotiations. So the HUTs were not involved in this at all. Because remember, they already said lack of corporate governance. However, they received copies of the joint and several guarantees after they had been executed by Zone America on the 1st of April. The HUTs also received documents in connection with the Itaú and the Banco Balboa loan. On the 7th of June, 2013, the HUTs in their capacity, quote, as representatives of Sienna Enterprises, the shareholders of 43.5% of Zone America Limited, and as directors of Zone America Limited, sent a letter to the general manager of Itaú stating, inter alia, that, quote, we cannot agree with the terms and conditions you're offering for the financing, end quote, and, quote, for good order, we notify you that we will use all means available to us to block this loan or the repayment thereof. The HUT sent a similar letter to Banco Balboa. At a meeting of Zone America shareholders held on the 27th of December, 2013, and notice when this is done now. When did they sign the agreement for the loan?
Was it 2013?
April.
Yes.
April 2013. So at the meeting of the plaintiff shareholders held on December 2013, with the affirmative vote of the majority shareholder, America Real Estate Investments Limited. Remember how much did they own? 56.5%. The defendants were not elected to be directors of the plaintiff going forward. So what just happened?
They got ousted.
That's right. Why?
Because they was causing problems.
So Zone America and its subsidiary was looking to raise money for whatever's the nature of their business, and they were blocking it. So Zone America, in their claim, they stated that the defendants, that's the HUT's conduct, constituted a breach of their fiduciary duties and an unlawful interference with Zone America's economic interests, and which caused Zone America's loss and damage. So by their conduct described in paragraphs 10 and 15, the HUTs acted in a fundamental or willful breach of their fiduciary duties to Zone America. They acted in breach of their common law duties as directors of Zone America. They acted in breach of their statutory duty to Zone America under Section 55 of the IBC Act, and or unlawfully interfered with Zone America's economic interests with the object, purpose, intent, and effect of causing damage to Zone America. In particular, the HUTs unlawfully and wrongfully interfered with Zone America's negotiation of the Deutsche subordinated loan by sending their letter, which was intended to and did cause Deutsche to decline to make the Deutsche subordinated loan. The HUTs failed to exercise any independent judgment when sending their letter and failed to consider properly or at all how such letter would be in Zone America's best interest. Sounds familiar? So even though his response was he didn't like the interest rate, he has to think about what's in the best interest of the company. Like, what was the company trying to achieve? And whether or not that could have been, or whether or not that was the best rate that they could have gotten. So as a result of the HUT's action, Zone America has suffered loss and damage. The said loss and damage was caused by the HUTs: 1, willful breaches of their fiduciary duties, breaches of their common law duties of care, breaches of their statutory duty of care under the IBC Act, and or unlawful interference with Zone America's economic interests. So as a direct result of not receiving the Deutsche subordinated loan, Zone America and the subsidiaries suffered loss and damage. The underlying businesses of Zone America were deprived of the use and proceeds of the Deutsche subordinated loan in the sum of $20 million, which caused Zone America and the subsidiaries to restructure the transaction relating to the construction and rental of the office building for Trafigura PTE, and transfer the Armored Drugs building and the Merrick building to third parties, in each case causing the plaintiff's underlying business to lose rental income. As the 100% shareholder in each of the subsidiaries, loss occasioned to the value of Zone America's shareholding in each of those companies. Loss of profits resulting from the diminution in the subsidiaries' profits. So, the main thrust of the defense contained in paragraph 14 of the amended defense, which provides that, further, the HUTs aver that if the alleged losses particularized in paragraph 20 of the statement of claim was suffered, which is not admitted, those losses were not suffered by Zone America, but by the subsidiaries, Zone America SA and Inversiones SA, and that Zone America cannot seek to recover losses which it has not directly suffered. Specifically, the losses described in paragraph 20, subparagraph 1 through 3, as having been suffered by Zone America are, as described, merely reflective of losses actually allegedly suffered by the subsidiaries, neither of which is a party hereto. Zone America's reply to the defense is set out in the amended reply, which provides as follows. With regard to paragraph 14 of the amended defense, Zone America contends that its loss was a direct loss on the basis that Zone America was to be a co-guarantor and or co-borrower of the Deutsche subordinated loan. The proceeds derived from such loan was intended to finance Zone America's underlying business operations involving the construction of rental and buildings. As a direct result of the Hutz letter, Zone America's underlying businesses were deprived of the use of the proceeds of the Deutsche subordinated loan. So alternatively, even if the loss claimed by Zone America is reflective of the losses suffered by the subsidiaries, which is not admitted, Zone America is not barred from recovering such loss. The Hutz were directors of Zone America only, but not of the subsidiaries. The Hutz owed fiduciary duties, common law duties of care, and statutory duties of care to Zone America only, but not to the subsidiaries. The subsidiaries have no cause of action against the Hutz for the breach of such duties or for unlawful interference, as the unlawful means for the purpose of that tort consists of the breach of such duties. The Zone America has an independent cause of action of its own against the Hutz. Zone America and the subsidiaries do not have coexisting causes of action against the Hutz. So the Hutz gave evidence in their defense. So let's see what they say. So then the court went to the leading cases. They deferred the case of OGB and Allen. And let me go to where he's coming down to. He is coming down. So at paragraph 23, he says, I did not find any merit in the first of Zone America's submission that its loss is a direct loss because it was to be a co-guarantor or co-borrower of the Deutsche loan. The evidence was clear that Zone America was to become a co-guarantor or co-borrower. That position afforded the Zone America's liability only and not any financial gain. It is difficult to attribute the loss of the opportunity to stand as guarantor as a direct loss, or that the rescission of the Deutsche loan to the subsidiary companies occasioned a loss to Zone America, which was other than reflective of the losses in its subsidiary companies. Zone America's second proposition was that this case falls within the exception to the general rule against reflective losses, as in the case of Johnson and Wood. In particular, Zone America says the present case is factually very similar to all of the authorities cited above. And Zone America contends that it falls within Lord Bingham's second proposition, which gives a shareholder the right to sue on a loss suffered when the company does not have a cause of action. The plaintiffs or Zone America's cause of action against the Hutz for breach of fiduciary duty, common law duty of care, statutory duty of care, pursuant to Section 55 of the IBC Act, and unlawful interference with its economic interests are not available to the subsidiaries, as during the relevant time period, the Hutz were not directors of the subsidiaries. Accordingly, the Hutz did not owe the subsidiaries any fiduciary duty, common law duty of care, or statutory duties of care. With regard to the unlawful interference action cause of action, it is submitted that the unlawful means for the purpose of that tort would consist of the breach of fiduciary duties, common law duties of care, and or statutory duties of care. As the Hutz did not owe the subsidiaries any of those duties during the relevant time period, a breach therefore does not arise. Consequently, the Hutz actions cannot be unlawful vis-a-vis the subsidiaries. So he goes on. He says at 28, further, based upon Lord Hoffman's definition in OGB Limited of what is unlawful means I am unable to determine that the fact of the HUT's position as directors of Zone America and not the subsidiary companies brings it within the exception to be general rule. The primary question is whether the acts complained of was intended to cause loss to Zone America by interfering with the freedom of Deutsche Bank in a way which is unlawful as against Deutsche Bank and which is intended to cause loss to Zone America. It seems clear that the unlawfulness or wrongfulness of the conduct is wholly unaffected by the existence or breach of directors or fiduciary duties. More pointedly, the presence of directors' duties do not empower Zone America any more than does it empower the subsidiary companies to pursue a claim for unlawful interference with their economic interests. In all the circumstances, I am not satisfied that this is an appropriate case for the application of the exception to the rule against reflective loss, and the general rule ought to prevail. For the reasons set out herein, I dismiss Zone America's claim. Unless Zone America submit otherwise, they must pay the costs. So what was Zone America trying to do?
They were trying to hold the directors liable for not exercising proper, to put it basically, duty and care, but I mean, I guess, but I got kind of caught up on, I don't understand how that whole loan proposal or whatever could have been entered into without the directors involvement from the outset. I mean, this is, I guess, just a large conglomerate and these decisions are made without directors or shareholders?
Yeah, the shareholders signed it, you forget? Months later.
Yeah, but not all, only one, the
shareholder-
majority.
Majority shareholder did it. And then don't forget that everything depends on what's in the articles. That's why the articles probably were amended.
But also the shareholders, yeah, I mean, I understand, we don't know what the articles say, but I mean, the directors are responsible for the day-to-day management of the company. So, you know, I was just taken aback by the fact that the directors had no involvement in that decision to enter into this loan, like even to sign the loan documents, like, you know, who signed those?
I guess the majority shareholder along with the directors. But it went, it passed. It passed. Because he owned 43%, they owned 56.5%, and they approved everything. And they got the loan. So whatever combination, they had the capacity to do it.
Yeah, that's unbelievable considering that the directors were the ultimate beneficial owners of the whole setup, and they lost or could have, well, didn't have control and could have potentially lost all control.
Yeah, because they didn't appoint them as, they removed them as directors. They still stayed as beneficial owners, but they were removed as directors. Because I guess in Zone America's view, they were trying to expand their business, and you were not looking at what was in the best interest of the company. So they figured that they weren't making good business decisions, so they had them removed.
Crazy stuff.
Yep. Yeah. And this is what happens out there in the real world. And you see, remember now, if we as an FCSP, we may have this company, no clue what they're doing, you know. But you see, these little IBCs, they're involved in a lot of heavy business. So you have that IBC Zone America here, but you see what it has? 2 subsidiaries in Uruguay. You see what kind of transactions they're dealing with?
Sure. I mean, there's always a reputational risk, even if you
Yeah.
find out what the business activities are.
Mhm.
And you don't provide directors, your name can still be involved in any sort of, you know, adverse news or whatever.
Mm-hmm. And then the same thing where the minority shareholders also the director. Then that's supposed to have given him some control. But you see, when he wasn't doing what they wanted him to do, the major shareholder just took over. So after that, he was practically silent. Yep. Mm-hmm. Yep. So I'll leave investor until we do liquidation, but that was another good one.
Yes, I did read that. That was easy to follow and it
Yeah.
was interesting. And I don't believe that amendment has yet been made to the IBC Act.
I don't think so either. But I
There
think
was something in the paper last year, I think, where that was brought to light again. And we were embarrassed as a international financial center to have still not yet amended that portion of the act.
But I mean, I don't know if this will go, how far this will go, especially how they removed the central bank from their saying policy decision. I mean, I don't know. But it was
Can I switch? I mean, sorry, I don't
ahead.
know. I feel like I keep cutting you off. And if you're not finished with that whole thing, that's fine
No, I'm
too.
done.
But I wanted to ask a question about the beautiful capstone question.
Oh, go ahead. Go ahead. me
Okay,
put-
I mean, it was just really the first one. I haven't gotten past the first one yet. But in looking at it, finally looking at it with some sense, I wanted for you to clarify, please. I mean, I can't pull it up right now for some reason, but it says to draft, I mean, it says table A, but I assume that's the first schedule, which are the articles of association. It says to draft the main operating clauses, which I interpret as the articles of association. So are we drafting the entire articles of association of a company's act company and
No.
inserting?
No, no,
Okay, because that seems like what the question said, and I
No.
was like, no way, because I know
changed.
when you originally explained it, you said that we would only make suggestions as to what should be included in any amendments to that first schedule.
yes, that's what I want. Just the changes or amendments.
So how would that work? I mean, like, suppose I only feel, I can only find 2 and somebody else thinks there's 15. I don't understand how that could be objectively and marked or interpreted or whatever you want to say.
Well, okay, let's say you only give 2 and someone gives 6. You have to give the rationale for it. Everything is based on the rationale.
So our guidance then should be the what do
The
you call it?
UK model articles that I sent you.
Right, because I mean, I looked at that. So in actuality, I mean, okay, I work with companies, not necessarily company act, and I don't always, work with the intention of, gosh, this would be a lot better if the articles had this provision in it. So
Mhm.
basically what our guidance should really be is looking at that UK, the latest of the UK table A, and pull from that what we would think would assist in, properly
Yes.
administering these. Okay, and
Mhm.
then you said, and give rationale as to why. I mean, suppose it's super obvious, like, you
Mhm.
know, it, okay, all right, no problem.
Yeah,
Thanks.
it's not difficult. It's not difficult at all. And that's why I say you could do it individually, or you could do it 2 persons together or 3 persons. But you must give justification as to why. Because I was just telling you, as I was telling you all, and a lot of other jurisdiction, these legislation are constantly being amended. But you don't see
I don't
that.
think we've had one for a long time.
Yeah, exactly. And that's why when I saw the recent amendments, again, I said, you know what, that'll be a good exercise because it also exposes you to see how other jurisdictions are moving forward. So when there are matters, you can see why the decisions are so different from the
Okay,
we make here. So it's for knowledge basis.
okay, I mean, yeah, that's good clarification because I couldn't see the purpose of setting out entire articles of
no.
association of a company.
Not the entire thing, no. No.
And then I
That-
do have one more question.
Go ahead.
I've been checking my emails all week since Sunday when you told us you was to give us our grades. I don't see nothing yet.
I gave it to Mr. Pratt. He should be sad, remind him. He has some.
Mr. Pratt, it looked like I gotta go call him, eh?
Mr. Pratt, right on here on mute.
He right here.
Mr. Miguel, kindly send our grades, thanks.
Yes, he has it. It's done.
Okay,
I'm
so we'll
reminding
be
him right
getting
now.
those today.
Yeah,
Okay.
I'm telling you right now.
These people don't know, we some anxious filled people, eh? Plus we wanted, you know, as like Althea had said, guidance to to see if we were on track with our midterm as to be able to assist us with doing this capstone. So like we're waiting all week to,
Oh,
you
okay,
know.
he has it, he has it, he has it. I won't say anything else. He has it.
Okay, thanks.
Okay? All right, let me see. He's online, so he should be, and I see 2 texts, so I guess he'll send them out.
Okay, I won't be mad at you anymore then.
No, see, he said yes. Okay, so I can tell him. They are
Yeah,
waiting
he need to send that while we in class.
for their grades. Now, okay, so I sent it to him. So let me see. Nobody failed based upon what he said, okay,
That's good to hear.
yeah. I do have one more. 2 more, come up. 1 more, 2 more, let me see. 1, 2. 1, 2, 3. 1, 2, 3, 4. I'm missing somebody. I have her. I have her. I have her. Yeah, yeah. All your grades are here. Everybody who's on today, your grades are ready. He has it. It's all done. Nobody failed. No one got below.
Great.
No one got below 50. No one got below 60.
Ooh,
And
good.
one got below 70.
Excellent. Thank you.
So I have one more to mark. I'll do that one and send that to Miguel, but all the other ones, yes. Okay?
Okay,
Thank
thank you
you.
for the week of stress.
All right, so we will chat next week. I'll see if I can find another case for you all. Or
You're
they,
so kind.
if I can find, there aren't a lot of company law cases, but I'll see if I can find one.
I
Okay?
really don't like the Bahamian law cases.
You like them?
No, ma'am.
Okay.
No, they
Try
like,
get
no,
Indira
they're not
Charles's.
bad. they're not bad, but just reading it kind of gets you kind of confused somewhat. However, the Wikipedia ones, I don't know, because they're summarized, I get the point faster. Like I understand exactly where they're coming from, even with the ruling. But as it relates to the Bahamian ones, it's be like 18, 20 pages. By the time I get so far,
You ready to
I
forget?
do no, I do remember. I do remember the path I'm going on, but I
Yeah.
kind of get us straight because it's so
Okay.
long. Maybe if they were like 10 pages, like what you did today, I got to follow you because I was listening to you as you go. But at
Mhm.
some point, I started to get lost. But where they repeat themselves, then I'll catch back up on what's going on.
Okay, okay. All right, understood, understood. I'll see if I could find one. If not, I'll
Yes,
probably
and
use a British
Indira
case.
Charles is much better at
A British one
summarizing
is
her
nice.
judgment.
Yeah, her judgments are clearer.
Yes, although
Yeah, you can
Wind,
tell
I
the
mean,
difference.
yeah, he was good with that one. Was it Jet Test or whatever it's called? So, I mean, that was clear, but that one with the one you just read, I got so lost as to, because of the different tiers and if they were
Mhm.
directors at the time and all that sort of stuff. And I was like, oh. So I scrolled to the bottom, I saw the decision. I was like, okay, I'll go from here.
Yeah, yeah, it depends. The same way,
Yeah.
like we found out from reading on Marla's case, it depends on the attorneys who present the matter.
Mm-hmm.
Yeah.
She was pretty good.
Yeah,
I mean,
so
her summary was clear,
yeah.
very clear.
so everything depends on who is doing
Yeah.
what. But I'll see if I can find. If not, like I said, I'll probably find an English case. Because we
All
have more
right,
English.
I will be waiting so gleefully.
For the English case.
Why she sit there? She holding me to the gun. All right. I'll see what I can find. All right.
Okay, thank you.
Okay. All right. Have
Bye.
a great weekend.
Yes, you too.
Okay.
Good
Bye
evening,
bye.
everyone.
Bye.
Thank you. Good day.
Bye.
All right.
Bye.
Hmm.